Good evening, friends. And we have Mr. M. Karunanidhi, who already done various sessions with us. And I can say that whenever he comes on a platform, he always shares his knowledge, which are enlightening. And today's topic, as we all know, is impact of admissions and confessions in a criminal trial. On the first blush, you find that there shouldn't be any distinction between admissions and confessions. But eventually, once you go through this legal journey being shared by M. Karunanidhi, the former member of the Law Commission of India, who is also special public prosecutor in CBI cases in High Court, you would come to know the subtle differences. And those who have missed the earlier sessions by Mr. Karunanidhi, they can visit the YouTube channel of Beyond Law CLC and get themselves enriched. Over to you, Mr. Karunanidhi, and thank you for accepting our invite. Yeah, we can start.
Yes, Jay. A very good evening to one and all, and thanks for the opportunity to meet my learned brothers and sisters through online. The topic of the day is the impact of admission and confession of an accused in a criminal trial. No doubt, the prosecution has to prove the charges beyond all reasonable doubt. The prosecution will come to the court by way of a positive final report, and prosecution will march oral evidence and documentary evidence in order to prove the charges on the materials forwarded under 173 subclass 2 CRPC. The learned trial judge will take cognizance of offences and will frame the charges and order for trial. Once the charges has been framed by the learned trial judge, the trial is said to have commenced. As soon as first information report is registered, investigation into an offence is started. Investigation begins as soon as FIR is registered. Trial is said to have commenced as soon as charges are put. No doubt, prosecution will come to the court with a bunch of documents. Whenever we go to the police station, the station house officer will ask the person who has come to the police station for evidence. If we are preferring a report to him, he will ask for some evidence. If police officer files final report, he has to annex some oral evidence and document evidence. If complaint under 200 CRPC is filed before the court, the learned trial judge will ask for some evidence. Even if you are complaining with your neighbor or your friends or in Panchayat, they will ask for evidence. So, evidence is very much important, and so also the topic is very much important. It is vital. No doubt, prosecution has got duty to prove the charges. The shoulders of the prosecution is heavily burdened. What is to be proved by the prosecution? The disputed facts alone has to be proved by the prosecution. If we are not disputing, that means there is a inherently we are admitting something. What is confession and what is admission? Confession means admission of guilt. Confession means admission of guilt. Either it is a criminal trial or it is a civil trial. The Indian Evidence Act 1872 and the Bharatiya Shakshaya Adhinayam 2023 will govern both the field. Let me take my learned brothers and sisters to section 5 of Indian Evidence. Before that, I may add, whenever my brothers or sisters are presenting some document, either before the civil court or before the criminal court, we used to oppose. Sir, this is inadmissible into evidence. This document, either by citing section 17 of the Registration Act or some other provision, we used to say some of the document is inadmissible. If the prosecutor is proposed to examine a witness and propose to mark a document, the learned defense counsel will say before the learned judge, my lord, this document is inadmissible into evidence. My respectful submission and small question before my learned brothers is whether any list is given appended in Indian Evidence Act or in any other law, citing or giving a list, the following are the admissible document or the following are inadmissible documents. No such list has been appended. Like the same, the interlocutory orders governed by section 397 CRPC, what orders are termed, what orders can be termed as interlocutory orders has not been defined. Now let us say whether confession has been defined. The term confession has not been defined in the Indian Evidence. The entire admissibility or inadmissibility of a document is governed by Indian Evidence Act. Let me take my learned brothers and sisters to section 5 of Indian Evidence. Section 5 of Indian Evidence. Let me read section 5 of the relevancy of facts, chapter 2. Section 5, evidence may be given of facts in issue and relevant facts. Evidence may be given in any suit or proceeding of the existence or non-existence of every fact in issue and of such other facts as are hereinafter declared to be relevant and of no others. So the prosecution is expected to adduce only relevant evidence, only relevant documents. So my brother may ask, sir, how section 5 is relevant to the topic? You may ask or you may not ask. This may be around your mind. How section 5 is relevant? Let me take my learned brothers and sisters to section 24 of Indian Evidence Act 1872, 25, 26, 27 and the section 30 of Indian Evidence Act are very relevant to the topic. Let me take to section 24, confession caused by inducement. Confession caused by inducement, threat or promise when irrelevant in criminal proceedings. A confession made by an accused person is irrelevant. We are happy when we are reading this portion alone. A confession made by an accused person is irrelevant in a criminal proceeding if the making of the confession appears to the court to have been caused by any inducement, threat or promise having reference to the charges, a charge against the accused person, proceeding from person in authority, reference to the charge against the accused person, proceeding from the person in authority, and so on. So, if confession of an accused is obtained by either by inducement or threat or promise, it is irrelevant. Let us come to section 25. Confession to police officer not to be proved. No confession made to a police officer shall be proved as against a person accused of any offense. So we are so happy with section 25 when in all the sessions offenses and in all the offenses relating to property, we can see in a list of document appended in the final report that confession and the disclosure statement. As per section 25, confession to police officer not to be proved. Confession to police officer not to be proved. So we the lawyers are so happy, but we have to go 26 and 27 of evidence. When I read section 27, section 27 is a proviso clause. Section 27 of Indian Evidence Act is a proviso clause. Let me read. How much of information received from accused may be proved, provided that when any fact is deposed to as discovered in consequence of information received from a person accused of any offense in the custody of a police officer, so much of such information, whether it amounts to a confession or not, as relates distinctly to the fact thereby discovered may be proved. Here we want to earmark, we want to underline the word whether it amounts to a confession or not, as relates distinctly. These words are very, very important. The lawmakers so carefully, so cautiously coined these words. Let me read once again. It has got very much importance. So much of such information, whether it amounts to a confession or not, as relates distinctly to the fact thereby discovered may be proved. The topic is impact of admission and confession. Impact means how confession before the criminal trial. How the confession of an accused can be used before the criminal court. Let me divide this lecture into two parts. Let us consider pre-cognizance stage and post-cognizance stage. Pre-cognizance stage means what? When final report is filed, the learned judge is going to take cognizance of offences. What is the meaning for taking cognizance? The term taking cognizance has not been defined in the Code of Criminal Procedure. So, as per section 190 CRP, as soon as the learned judge applies his judicial mind into the facts of the case and come to a conclusion that so-and-so offences are made out, the learned judge is said to have taken cognizance of offences. Please make it clear, it is only a cognizance of offences. No cognizance has been taken as against any accused. It is only a cognizance of offences. Cognizance means taking note of. So no doubt, sir, when final report is before the court, learned judge is taking cognizance of the offences. Whether the bar created under section 24 to 27 of Indian Evidence Act applies to take cognizance? No. When FIR is registered, investigation into the offences has been started, statement of witnesses has been recorded, and as per the materials collected during the investigation officer came to a conclusion that A has committed an offence. There are prima facie materials available before him. The information, there are differences between the first information as defined as per section 154, section 41 CRPC, and in section 167 CRPC. There are different kinds of information, sir. So, in high pedestal, the investigating officer collected some more materials to show that so-and-so has committed some offense, prima facie. So now the investigating officer forwarded the accused before the learned judge with the request to take him into judicial custody. Along with the accused, request to remand the accused, first information report, first diary as contemplated as mandated under 167 2 CRPC, and confession of the accused is placed before the learned judge. Now, my question is whether the learned judge is expected to apply his judicial mind, expected to go through the confession, or is there any bar to the learned judge to consider the confession of the accused in order to take him into custody, in order to recognize the custody of the accused who is already in custody of the police officer? The custody has to be recognized. No doubt at all, there is no ban, there is no bar. Learned judge, at the time of taking the accused to the custody, the statement of the witnesses and a recorder under 161(3) taken into consideration, confession of the accused can be taken into consideration. No doubt, remanding an accused can be passed, valid remand order can be passed only by application of mind. So also, the order of remand amounts to taking cognizance. In a case from Karnataka High Court, the Honorable Supreme Court came to a conclusion, the sanction required to take cognizance is different. It is only at the time of considering the final report. So the ban to take cognizance, bar to take cognizance will not be applicable when an accused is forwarded with a limited prayer to take him into judicial custody. So also, when accused is before the learned judge during investigation stage for the purpose of taking him to custody, that is under section 167 1 CRPC, an application to take him to custody is before the court, there is no ban, there is no bar to go through the statement recorded under 161(3) CRPC as well the confession of an accused. So it is a pre-cognizance stage. At the time of another example, no doubt final report has not been filed. It is only an investigation stage. Some properties have been collected. It has been placed before the learned judge as taking the accused into judicial custody. The properties recovered during investigation has been placed before the court, and the learned judge will take the property into custody. RP order will be given and number will be assigned, RP number so and so so on. Now the question is disposal of property, an application under section 451 to 457, an application for return of property or disposal of property is before the learned judge. Whether the learned judge can take into consideration the confession of an accused or the bar contained under 24 to 27 of Indian Evidence Act will apply. This is settled law. When the guilt of the accused is going to be proved and a trial is on, when prosecution is marching evidence after framing of charges that the trial of an offense is going on, the bar under section 24 to 27 will come into play. Before taking cognizance, at the time of making remand, at the time of consideration of application for disposal of the property, either before taking cognizance or after taking cognizance, the ban or bar will not be applicable. So no doubt at all. The impact of confession of an accused before the police officer is, or confession of an accused before his friend, or before a village administrative officer, or before a doctor, that is known as extrajudicial confession. The learned judge can consider to arrive at a conclusion to find out whether prima facie case is made out or not for the purpose of taking an accused into the judicial custody, to take cognizance of offences to issue summons to the accused, the confession of an accused before the police officer, extrajudicial confession and judicial confession can be looked into. There is no bar at all. Let me read. The confession before police officer and confession before extrajudicial confession and judicial confession. There are three types of confession. And confession before the village administrative officer. Insofar as the state of Tamil Nadu is concerned, Rule 72 of Criminal Rules of Practice was there. Now the new Criminal Rules of Practice has been framed by the Honorable Madras High Court. Before that, the confession of an accused before the village administrative officer in most of the cases covered by circumstantial evidence. We have seen number of cases. As a prosecutor, as a defense counsel, definitely there will be a confession before the village administrative officer. The accused will go to the village administrative officer. He will confess before him and he will reduce into writing and he will produce the accused before the police officer. Again, the police officer will record a confession after arresting the accused. Now, the point for consideration is whether a village administrative officer is correct, whether he has got power to record confession of an accused after the investigation has begun. Rule 72 of Criminal Rules of Practice speaks about village munsifs are absolutely prohibited from recording confession of an accused after the police investigation has begun. There are numerous judgments from the Madras High Court. The VAO has no right to record the confession after the investigation has been started, and the confession of an accused before VAO, extrajudicial confession, was thrown away. It was considered by the Honorable Supreme Court in Sivakumar versus State of Tamil Nadu. The Honorable Supreme Court categorically discussed and distinguished the village munsif and the village administrative officer, and finally came to a conclusion that Rule 72, as framed by the Madras High Court in 1948, is nugatory, and so now the new Criminal Rules of Practice 2019 has been framed by the Honorable Madras High Court. No such rule is now framed, is available in Madras High Court. So, extrajudicial confession, there is no bar for village administrative officer to record confession. Extrajudicial confession, there is no ban. Initially, I have stated that there should not be any coercion, threat or promise. Equally, there is a provision in the Code of Criminal Procedure. Let me take my learned brothers and sisters to section 316 of Code of Criminal Procedure 1973. Let me read section 316. No influence to be used to induce disclosure, except as provided in sections 306 and 307. No influence by means of any promise. You underline the word except as provided in sections 306 and 307. No influence by means of any promise or threat or otherwise shall be used to an accused person to induce him to disclose or withhold any matter within his knowledge. Within his knowledge. Conjointly, we can read section 24 of Indian Evidence Act 1872. Confession caused by inducement, threat or promise when irrelevant in criminal proceedings. So, in a criminal proceedings, confession caused by inducement, threat or promise are irrelevant. Those confessions cannot be looked into by the court. So, how we can come to a conclusion that the confession has been obtained by promise or threat or whatsoever. During the cross-examination, we have to elicit the accused was threatened, or there was a promise, or there was an inducement to the accused to obtain the confession. If there is some evidence, then the confession is irrelevant. Now, another question is, as per section 2H CRPC, equally section 2(1) L of BNSS, investigation means what? Investigation means collection of all evidence. Let me read section 2H of CRPC. It is very, very relevant. Investigation includes all the proceedings under this code for the collection of evidence conducted by a police officer. Now my question is, so once again let me read. Investigation means collection of all evidence. By a police officer. So investigation officer is collecting evidence. He is recording statement of witnesses under section 161 subclass 3 CRPC. Is it evidence? Question number 1. Investigation officer during his investigation recording the statement of witnesses under section 161 3 CRPC. Is it evidence? If so, whether the prosecutor can exhibit it, whether the learned prosecutor can mark it as a document. During investigation, there was an interrogation of an accused. He gives voluntarily a statement admitting the guilt. Confession of an accused has been reduced into writing. It is also during investigation. Can it be termed as evidence? Let me say it is evidence. How? Sir, section 24, just now you only read section 24 of Evidence Act, 25 of Evidence Act, 27 of Evidence Act. How can you say it is evidence? This may be in your mind. So consciously I am telling it is nothing but evidence for a very limited purpose. Statement of witnesses under section 161 subclass 3 is also evidence. Confession of an accused recorded by police officer is also evidence, only for a limited purpose, to take cognizance of offences. As I already discussed, in pre-taking cognizance stage at the time of making remand under section 161 subclass 2 CRPC, under section 190 CRPC, to apply judicial mind into the facts of the case for the purpose of taking cognizance of offences in order to conduct a trial, to find out in the result, net result, to come to a conclusion that there is a prima facie case. These are all evidences. Then what has been prevented? As per section 5 of Indian Evidence Act, only relevant evidence can be adduced by the prosecution or by defense or by any party. It applies to both civil and criminal. So strictly by speaking, section 5 of Indian Evidence Act will come into play. Equally in Bharatiya Sakshaya Adhinayam there is a provision. So, and section 24 of Indian Evidence Act is now in section 22 subclass 1 of BSA. Section 25 of Evidence Act, section 23 1 of BSA, and 27 is to proviso to section 23 of Bharatiya Sakshaya Adhinayam. Confession of an accused before police officer, judicial confession, extrajudicial confession. In order to apply Section 27 of Evidence Act, the ingredients of the Section 27 is to be borne in mind, and we have to keep in mind whether accused shall be in custody of the police officer or the statement of an accused when he is in custody is sufficient. Section 27 of the Indian Evidence Act is so clear. Accused need not be under arrest. Accused need not be under arrest. Section is so clear. Let me speak about the ingredient of Section 27 of Evidence. When any fact is deposed to, as discovered in consequence of information. So there must be some information. There must be some information from whom? Accused of any offense. From the accused. When accused of an offense, any offense, in custody of a police officer. In custody of the police officer. So the term custody has been used in Section 27. So simple custody is sufficient in the custody of a police officer. So there will be doubt. Police officer. Who is police officer? Now the point has been answered by the Honorable larger bench of the Honorable Supreme Court in Tofan Singh versus State of Tamil Nadu. Police officer overall will come under the category of police officers. Narcotic offense officers, railway officers, forest officers, they are all come under the definition of police officers as held by the Honorable Supreme Court in Tofan Singh case. So much of such information, whether it amounts to a confession or not. So much of information, whether it amounts to confession or not. So we have to underline whether the information passed on by the accused, whether it amounts to confession or not means what? It means simple statement. Then there will be a doubt whether statement of an accused can be recorded by the police officer, whether it will come under Section 161(3) CRPC or not. Is there bar for the investigating officer to record the statement of an accused? No doubt, statement of an accused can also be recorded. Section 161(3) CRPC is applicable. Let me complete Section 27. As relates distinctly, you read conjointly Section 5 of Indian Evidence. Here also the word as relates distinctly to the fact thereby discovered. Section 27 begins with deposed to. When any fact is deposed to as discovered in consequence of information. So if some fact is discovered out of the information given by the accused, so what is required to apply Section 27 of Evidence Act is there must be some discovery of fact. That discovery of fact must be relevant to the charge. So only the word relates distinctly has been coined. Relates means relevant. The distinctly means what? Suppose in a given case, A is the investigation officer, he arrested B in connection with a charge of murder. A arrested B. Before that, as per the information, FIR was drawn up. The investigating officer went to the place of occurrence. He had seen the place of occurrence. He had drawn rough sketch. Some materials were there. It was collected through Caesar Magajan. So he was able to say when and where the occurrence happened. He was very clear, the investigating officer. In the first investigation, Investigating officer categorically came to a conclusion and recorded some statement from witnesses in particular place. The occurrence was done. Now, during the investigation, he arrested B. Now B says, sir, let me take you to the place where the occurrence took place. Only this statement has been passed on by B. Now my question is whether this statement will come under section 27 of Evidence Act or not. This statement alone will not come under the section 27 because this is not a distinctly recovered. The fact where the occurrence was happened already been discovered by the investigating officer during the course of the investigation. So this information given by the accused is not a newly discovered fact. So in order to apply section 27, and there must be some information. That information must be from accused. He must be in custody of the police officer. He need not be under arrest. That information must be related to the charge and it must be distinctly proved. It must be distinctly proved. Now let us say, as against A, FIR was drawn up. Investigation was taken up. A was arrested by the investigating officer. Statement of A was recorded. He admitted his guilt. Material objects which is very relevant to the charge, distinctly proved. That has been recorded and there is disclosure statement was also recorded. Some material object like lethal weapon was discovered by the investigating officer. Furthermore, he implicates two more accused whose name does not find place in the FIR. Now, investigation officer confirmed the participation of B and C. B and C also involved in the occurrence. So, it is known as confession of a co-accused. What provision deals with confession of co-accused? Let me take my learned brothers and sisters to section 30 of Indian Evidence. Section 30 of Indian Evidence. Consideration of proved confession affecting the person making it and others jointly under trial for the same offense. Consideration of proved confession. So, to apply section 30 of Indian Evidence Act, that the confession must be proved. Consideration of proved confession, it must affect the person making it and others jointly under trial for same offense. Under trial for same offense. The trial must be joint trial. The trial must be joint trial. So confession of co-accused can also be considered. And in order to apply section 30 of Evidence Act, there must be a joint trial. Kashmira Singh versus State of Madhya Pradesh will come into play. It was decided on March 4, 1952 by the Honorable Supreme Court. Kashmira Singh is a landmark judgment. There was a landmark difference between section 30 of Indian Evidence Act 1872 and the Bharatiya Sakshaya Adhinayam, section 24. Suppose there are 4 accused as against 2 accused. Since they have not appeared before the learned trial judge and the NBW was pending for quite long time as against the 2 accused. By invoking section 317 subclass 2 CRPC, case was split up. So new number has been assigned as against the 2 accused. Case is pending for quite long time. The case has been taken up later the point of time. The A who implicated the other two accused tried earlier, and there was a verdict. There was a verdict of conviction. Later point of time, and the two accused as against them, case was split up. Trial is on. Whether the confession given by so and so tried earlier can be taken into consideration. The answer is, since there was no joint trial, this cannot be taken into consideration. Now, deemed joint trial has been available in section 24 of Bharatiya Sakshaya Adhinayam. Section 24 of Bharatiya Sakshaya Adhinayam. Insofar as the confession of accused, let us discuss first about the extrajudicial confession. I request the learned brothers and sisters to take note of my mail ID. Please send here in the chat box your mail ID or send a word to my mail ID. I will send a notes, not only the topic on judicial confession, extrajudicial confession, and the relevancy of confession before a criminal trial, relevancy and the probative value of confession. I will send a mail. Please take note of my mail ID, kanlaw1971@gmail.com. KANLAW1971@gmail.com. I will forward a bunch of articles which contains a topic on judicial confession as well, relevancy and probative value of confession of an accused. Suppose extrajudicial confession is now before the court. The topic is impact of confession before the criminal trial, in a criminal trial. It means what? Learned judge, after recording evidence adduced on the side of the prosecution as well by the defense, going to give verdict by and after appreciation of evidence. How the learned judge will appreciate what are all the guidelines by the Honorable Supreme Court and various high courts insofar as the confession is concerned, confession of an accused. Let me take my brothers and sisters to extrajudicial confession. Suppose an extrajudicial confession is before a stranger. For example, A, who is an accused, went to B, who is closely related to the deceased. A gave confession, sir, for so and so reason, I only committed the murder of so and so, knowing fully well that he is confessing before the person who is closely related to the deceased. According to the Honorable Supreme Court and various high courts, when the confession, extrajudicial confession can be taken into consideration, the maker of the confession must repose confidence and faith on the person before whom the extrajudicial confession is given. It is impossible for a person to go before a stranger and to confess. Normally, we the people will repose confidence only on a closely related person. When a person is close friend, we will discuss with the fact. Whatever be the situation, one will discuss the same, not to the stranger and only to closely related or closely when we want to say something. If we repose confidence on the person, then only we will disclose everything. So also, as per the judgment of the various High Court and the Honorable Supreme Court, a case is very recently decided by the Honorable, let me say, one example from 2022 Live Law Bombay, page number 45. The maker reposes faith on the person before whom it is given to make before stranger is improbable. 2023 Live Law Supreme Court, page 989. 2023 Live Law Supreme Court, page 989. It is unusual for an accused to confess before real brother and a close acquaintance of the deceased. It must be a sterling quality. Prabhabadi versus State of Gujarat. And extrajudicial confession is a very weak piece of evidence. It depends on the person to whom it is made. Independent corroboration is always necessary. Independent corroboration is always necessary. There are numerous decisions, and one of the judgment is 2023 Live Law Supreme Court, page number 197. 2023 Live Law Supreme Court, page number 197. Pawan Kumar versus State of Bihar. And one more question is, no doubt there is a confession of co-accused. No other materials are available. Whether on the strength of the confession of a co-accused, can we record conviction? This has been decided. Subramania versus State of Karnataka. Subramania versus State of Karnataka. Live Law 2022 Supreme Court, page 887. Extrajudicial confession cannot be relied upon as a substantive piece of evidence. The confession of co-accused cannot be given credence as a substantive evidence. So this cannot be taken into consideration. 2025 Live Law Supreme Court, page number 97. Sadasiv versus State of Maharashtra. Village police Patil is not a police officer, so confession to him is admissible as extrajudicial confession. Very recently, the Honorable Madras High Court in R. Krishnamurthy versus State. 2025 Madras High Court, page number 261. Placing reliance on the Haricharan Kurmi versus State of Bihar judgment of the Honorable Supreme Court. The Honorable Madras Division Bench of Madras High Court rejected the prosecution case, and more particularly, confession of co-accused was rejected as it was not a substantive piece of evidence. Acquittal was recorded. 2025 neutral citation INSC 167 Raja Khan versus State of Chhattisgarh. Glaring inconsistencies concerning recoveries made by police pursuant to alleged disclosure statement made by the accused. Since there was a discrepancy which is inconsistent, which is glaring inconsistencies are available as per the disclosure statement. So it was rejected by the Honorable Supreme Court. Raja Khan versus State of Chhattisgarh, 2025 INSC, page number 167. In order to appreciate the evidence, the appreciation of evidence is a very, very important both for a civil court and for criminal court. In criminal court, we are following the policy. Prosecution has to prove the charges beyond all reasonable doubt. So the prosecution's shoulders are heavily burdened. there are so many factors to reject the prosecution version. In general, when we are defending an accused, for example, we are defending an accused in a case of murder or any other case. First impression is the best impression. So the first information report has got its own importance. So we have to take care of creating more doubt regarding the manner in which first information report was registered. When the first information report was forwarded to the court concerned, whether first diary was forwarded to the court when the accused was produced before the learned magistrate with a request to take him into judicial custody for the first time, whether the confession and the disclosure statement as well the Form 91 or Form 95 as the case may be, by which the weapon or the material object were recovered has been produced. We have to concentrate when the documents have been prepared by the investigating officer, when those documents have been forwarded and received by the learned judge. There are guidelines by the Honorable Supreme Court. If there is a delay in forwarding the discoveries, the discovery memo or Caesar Magazine and Form 91, in some cases, within 24 hours, accused will be produced before the learned magistrate with a request to take him into custody. But the documents prepared on the even date, for example, Form 91 and Caesar Magazine will be forwarded belatedly. In a narcotic drugs cases, the Caesar Magazine and all other materials you forwarded belatedly to the court. I read some judgments and the cross-examination, the learned counsel elicited from the mouth of the investigating officer that the recoveries were made on particular date earlier, but it was forwarded to the court belatedly. The form on which the properties were produced before the court, the learned judge returned the form stating that produce it along with property, produce the weapon of crime, produce the arwal, produce the drugs along with produce the form along with the properties. That means what reasonable inference could be drawn as per the endorsement made by the learned judge. We can safely infer if really on the particular date those weapon of crime or the contraband was made ready. What prevented the investigating officer to forward those weapon of crime or material objects or whatever it be to produce along with the Form 91? So there are reasonable doubt to reject those confession leading to discovery of fact as well the properties. Those evidences is liable to be rejected. So the way we are concentrating on the confession of an accused and the disclosure statement, we have to take more care in reading the papers forwarded by the police officer and furnished to the accused. We have to go through the original documents a number of times. If we go through the original documents, we can find out some points. There may be some corrections through white paint. There may be material corrections that may not be matched with the one available with the CD file. When the investigating officer is giving evidence before the court, we must see if there are some corrections in the court. We have to compare with the one available with the investigating officer. Also, whether all recoveries are admissible under section 27 of Evidence Act. Let us discuss on the topic. In Sendil alias Sendil Kumar versus State. In Sendil alias Sendil Kumar versus State, 2017 volume 1 Madras Weekly Notes Criminal page number 62. Sendil alias Sendil Kumar versus State, in paragraph 20, it has been decided there is no nexus between the recovery of Arwal and the crime has been established. There is no nexus between the recovery of Arwal and the crime has been established. Hence, the same is rejected. Hence, the same is rejected. Next, mere matching of blood group. Mere matching of blood group on the blood-stained cloth would not lead to the conclusion that it is the appellant who had committed the crime. Recovery of laptop does not have any bearing. It is neither weapon of crime nor it is any cause of connection in the commission of crime. 2017 volume 3 SEC page number 832. Deepa Priya Paul versus State of West Bengal, paragraph 7 to 10. Deepa Priya Paul versus State of West Bengal. Laptop was discovered out of the confession. Leading, what was discovered is laptop. So I already read, relates distinctly. So related discovery alone is admissible into evidence. Here, laptop was discovered. It is I am really extremely sorry, brothers and sisters. Due to sudden power failure, I could not connect immediately. Another judgment, important judgment is 1969 to SEC 872, Jafar Hussain versus State, paragraph 15, paragraph 5. Essential ingredient of the section 27 is that the information given by the accused must lead to the discovery of the fact, which is the direct outcome of such information. Only such portion of the information given as is distinctly connected with the said recovery is admissible against the accused. Thirdly, the discovery of the fact must relate to the commission of the some offense. So the discovery must be related to the charge against the accused, and it must be distinctly proved. Let us discuss about judicial confessions. Section 164 CRPC. Section 164 CRPC speaks about recording of confessions and the statements. Before getting into section 164 CRPC, as I have stated, statement of accused can be recorded by the investigating officer relying upon section 161(3) CRPC. I am duty bound to read section 161(3) CRPC. As per section 27 of Evidence Act, it says whether it amounts to confession or not. Confession or not. The word not means statement. Confession or not means statement. Let me read section 161(3). 161, examination of witnesses by police. Any police officer making an investigation under this chapter, or any police officer not below such rank as the state government may, by general or special order, prescribe in this behalf, acting on the requisition of such officer, may examine orally any person. Please underline, may examine orally any person supposed to be acquainted with the facts and the circumstances of the case. So, as per the clear language contained in section 161 subclass 1, read with subclass 3 CRPC, statement of an accused can also be recorded, and it is further strengthened by section 27 of Indian Evidence Act 1872. Yes, let us go to section 164 of CRPC 1973. Section 164 speaks about recording of confessions and statement. Confession and statement. So, the mandatory provisions have been appended in section 164 CRPC. The points to be borne in mind at the time of recording the confession under section 164 CRPC is, before recording the confession, the learned judicial magistrate has to explain. The learned magistrate has to explain the person backing it, that he is not bound to make confession. That he is not bound to make confession. If he confesses, the same will be used against him. The learned judge has to warn and inform that he is not bound to make a confession. Still, if he make any confession, it will be used against him. And the learned judicial magistrate has to satisfy that whether the confession has been given voluntarily. If the person is not willing to make confession, the learned magistrate shall not detain him under the police custody. The learned judicial magistrate has to make a memorandum. The learned judicial magistrate has to make a memorandum at the foot of the confession as contemplated under subsection 4 of section 164. So exactly the memorandum has to be there. There should not be any alteration. With the letter and spirit, the memorandum must be recorded by the learned magistrate. Before recording the confession, the learned magistrate has to bear in mind the principles given by the Honorable Supreme Court of India in Chandran's case. In Chandran case and Ravindra Kumar Pal versus Union of India. In Chandran case, very important case reported in AIR 1978 Supreme Court. AIR 1978 Supreme Court, page number 1574. And 2011, volume 2 SEC, page number 490. 2011, volume 2 SEC, page number 490. In Ravindra Kumar Pal versus Union of India, reported in AIR 2011 Supreme Court, page number 1436. The observation of the Honorable Supreme Court is the provision of section 164 CRPC must be complied with not only in form but in essence. There are a number of guidelines has been given by the Honorable Supreme. According to section 164 CRPC, learned magistrate has to come to a conclusion first, whether the accused is given the confession voluntarily or not. How the learned magistrate can come to a conclusion whether accused has given confession voluntarily or not? The provisions are so clear. How to find out? Before recording the confession of an accused, the learned judicial magistrate has to ascertain whether the confession is voluntarily or not. In order to find out, in order to do the exercise, in order to find out the confession is voluntarily or not, learned judge necessarily has to put leading questions, but it should not like a cross-examination. It should not like a cross-examination by putting some questions to the accused. Learned judge has to come to a conclusion that the confession of an accused is going to give the confession voluntarily. There is no tutoring, there is no promise, there is no threat. The learned judge has to necessarily come to a conclusion it has been given voluntarily. By some leading questions, it must be recorded. I will give some judgments. AIR 1977 Supreme Court. AIR 1977 Supreme Court, page 1579. While recording confession, the magistrate not caring to ascertain whether it was voluntarily or not. So 164 3 CRPC was violated. The confession statement was rejected. Confession was recorded by putting leading question and accused is found to be virtually cross-examined. So only I said the questions to accused for the purpose of finding out the voluntariness of the accused. The question should not be like cross-examination. AIR 1981 Supreme Court. AIR 1981 Supreme Court, page 2007. State of Madhya Pradesh versus Dayaram Hemaraj. State of Madhya Pradesh versus Dayaram Hemaraj. Confession recorded by putting, not by putting leading question, and it was found virtually cross-examined. So confession was not relied upon. AIR 2002 Supreme Court, page 1192. AIR 2002 Supreme Court, page 1192. Ayub versus State of UP. There must be a satisfaction of the on the part of the learned magistrate. The subjective satisfaction. In many times, in many area, the Code of Criminal Procedure speaks about satisfaction of the learned magistrate. One such satisfaction is at the time of taking into at the time of remanding the accused by invoking section 167 2 CRPC, at the time of recording the statement dying declaration. So also when a statement or confession is recorded under 164 CRPC, there must be a subjective satisfaction of what regarding the voluntariness of the accused. The confession statement must be shown to have been voluntarily made. The question intended to be put under 164 4 CRPC should not be allowed to become a matter of mere casual and mechanical inquiry. The magistrate should be fully satisfied, that is, in fact and substance, voluntarily given. So the exercise of putting question to the accused for the purpose of finding whether the accused has given voluntarily or not is not a simple exercise. More care to be taken by the learned judge. More care to be taken. If in the given case, the complaints of requirement under section 164 subclass 2 CRPC have not been made out by the learned judge, then it cannot be treated as a voluntary confession as decided by the Honorable Supreme Court in Mahabir Singh versus State of Haryana. Mahabir Singh versus State of Haryana. Let me read out the few lines from the Supreme Court judgment. When it is proved that the compliance of requirements under subsection 2 of section 164 CRPC have not been made by the magistrate, it cannot be treated as a voluntary confession. AR 2001 Supreme Court, page 2503. Before putting questions, before recording the confession of an accused, the learned judge has to give some reflection of that. Reflection. If no reflection of time is given, then such a confession is to be rejected. Kundadharan versus State of Assam. 1977 Criminal Law Journal, page 13. And Kartar Singh versus State of Punjab. 1994 SEC Criminal, page 899. 1994 SEC Criminal, page 899. There are mandatory provisions contained in section 164 CRPC. So the learned judge, before recording the confession of an accused, has to give reflection of time to the accused, has to put some questions. It should not be like a cross-examination for the purpose of finding that the accused has given voluntarily. The confession has been given by the accused so voluntarily, and reflection of time must be there. So only when mandatory provisions contained under 164 CRPC has been followed, then only the judicial confession can be taken into consideration. Now another question is whether the power conferred under 164 CRPC can be exercised by a executive magistrate. Simultaneously, I am putting one other question. If there is no judicial magistrates are available in a particular area, no doubt, remand can be authorized. We used to call it in state of Madras remanding an accused. But it is nothing but authorization of the custody. By invoking the power under 167 subclass 1 CRPC. Procedure when investigation cannot be completed in 24 hours. Accused will be forwarded to the learned magistrate or learned judge for the purpose of authorize the detention of the accused. By taking an accused into the judicial custody, the learned judge is authorizing the custody, who is already in custody of the police officer, that custody has been authorized by taking such a person into custody. Let me read 167, subclass 2A. Notwithstanding anything contained in subclass 1 or subsection 2, the officer in charge of the police station or the police officer making the investigation, if he is not below the rank of sub-inspector, may, where a judicial magistrate is not available, transmit to the nearest executive magistrate on whom the powers of a judicial magistrate or a metropolitan magistrate have been conferred, along with a copy of the entry in the diary herein after prescribed relating to the case, and shall at the same time forward the accused to such executive magistrate, and thereupon such executive magistrate may, for the reasons to be recorded in writing, authorize the detention of the accused person in such custody as he may think fit for a term not exceeding 7 days in the aggregate. You read in between, the executive magistrate, if conferred power in the absence of a judicial magistrate, accused may be forwarded, transmitted along with the diary, but the term of custody not exceeding 7 days. Not exceeding 7 days. This power has been given to the executive magistrate. So now I am putting a question, whether the power conferred under section 164 CRPC can be exercised by the executive magistrate. This has been answered by the Honorable Supreme Court in Assistant Collector of Central versus Duncan Agro Limited, 2000 Supreme Court cases criminal, page 1275. 2000 SCC criminal, page 1275. The confession statement of an accused must be recorded by a judicial magistrate. If the confession of an accused is recorded by the executive magistrate, such a confession is inadmissible. Such a confession is inadmissible. As we have discussed, confession of an accused before the police officer is inadmissible. There are some ingredients to invoke section 27 of Indian Evidence Act. Accused must be in custody of the police officer, need not be arrested. There must be some information. Out of such information, there must be some discovery of fact. Need not be a material object. It must be discovery of fact and not material object. And those discovery must be related to the charge. And discovery must be distinctly to be proved. Extrajudicial confession. There should not be any extrajudicial confession before a stranger. And in almost all the circumstantial evidence cases, the prosecuting agency will come forward along with the extrajudicial confession. It is not a substantive piece of evidence. Insofar as judicial confessions are concerned, section 164 CRPC has to be followed in letter and spirit. In substance, the mandatory provision has to be followed. And in many cases, the extrajudicial confession before the village administrative officer has been placed before the courts. In many cases, the village administrative officer will produce the accused along with the letter to the investigating officer. The letter will also be tendered as evidence, as a document evidence by the learned prosecutor. My question is whether such a letter is admissible into evidence or hit by section 162 CRPC. After the police investigation has been over, investigation has been taken into consideration. The section 162 CRPC, statement to police not to be signed. How the statement of the witnesses before the police officer can be used in evidence. Use of statement in evidence. Section 162 is the concerned provision. As per 162 CRPC, statement to police not to be signed. So now my question is very clear. The village administrative officer before whom extrajudicial confession has been given by the accused, he reduced into writing the confession of the accused, and he produced the accused before the police officer concerned, who is conducting the investigation, no doubt that. Along with the letter, it contains something. My question is whether the letter written by the village administrative officer or any person producing the accused before the investigating officer is admissible into evidence or hit by section 162 CRPC. This position was also clear by the judgment of the Honorable Supreme Court insofar as the presumption is concerned. Kaliram versus State is a very, very important judgment rendered by the Honorable Supreme Court of India. According to the Honorable Supreme Court, the letter written by the person to produce the accused before the investigating officer is also it will also fall under section 162 CRPC. So it is inadmissible into evidence. Inadmissible into evidence. So with this, I want to conclude. And if any doubt, I request the learned brothers and sisters to put into the chat box, or you may go through. My articles contain several pages, running up to 100 pages. You may go through it, or please, one or two persons may put some questions.
I'm just checking it out.
My sincere thanks to my learned brother.
I'm just checking.
Namaskar to one and all. Jai Hind.
Thank you. And
by using this opportunity, I salute the nation. And my sincere salute to the soldiers and the Honorable Pradhan Mantri.
Same here. Everybody wants to cherish good moments. And those who have missed the earlier sessions of Mr. M. Karunanidhi, they can always stay connected on the YouTube of Beyond Law CLC and watch those sessions. And we will request Mr. Karunanidhi to share his articles. We'll post it on the website of Beyond Law so that everybody can see them, watch them along with the YouTube. Everyone stay safe, stay blessed. Namaskar.
I will send to you, sir, through WhatsApp. Contains nearly 400 pages. Let my learner brothers and sisters use it.
Thank you.
Thank you very much, sir, for having given me this nice opportunity to meet my learner brothers and sisters across the nation. Namaskar once again.
Thank you. And tomorrow's session is the Guardians and Wards Act 1890 by Mr. S.R. Somashekar, a former district judge from Bengaluru. Do stay connected with us tomorrow at 6 p.m.
Money